And for me, the question about the Digital Economy Act comes down to some quite simple issues. It comes down to questions about whether the Digital Economy Act will in fact be effective, whether it's proportionate, and what kinds of unintended consequences it might have, what kinds of impact on society, behaviour, internet take-up and so forth. And I think that my view, in answer to the question that we've been set today, what do you want to happen to the Digital Economy Act in 2011, is I hope it will have the robust scrutiny, debate and indeed impact assessment that it didn't have in 2010. Will this, the procedures, the expensive and cumbersome procedures laid out in the Digital Economy Act be effective? Can they be considered proportionate? I think there are some question marks about those procedures, and I think there should be, I'm an academic, so we always think there should be a lot more research done on whether that is in fact the case. I think it's quite clear from what's going on in the market this year that the legal market is in fact growing very rapidly and is competing very effectively with illegal downloads. And I think that there are a lot of questions about the extent to which the measures in the Digital Economy Act will in fact have the impact on the growth of the market that the rights-holding industry has claimed. It may be, for example, that consumers' demand for music and other services is quite inelastic, in the sense that they will not continue to demand music in the volume they have done when that music becomes free. The effect may be to shrink the market for music. And we've been there before. There are lots of questions about the new business models and the ways in which the music industry in particular could be responding to current opportunities. And I think we'll see a return to those debates. We're aware that there's a judicial review pending, and I think potentially we'll need to reopen some questions about those unintended consequences. During my work on the consumer panel on this, I became aware of a number of issues which I think remain cause for concern in the Phase 1 implementation of the Digital Economy Act. For example, the exchange of information between ISPs and consumers may result in consumer confusion about their own liability, particularly as regards wireless networks. I think it's very particularly important that the Digital Economy Act does not have the unintended consequence of giving people the impression that they have the responsibility to close their wireless networks, because I think the legal position is that you do not have vicarious liability within intellectual property law for the use of your internet connection. I won't go down the shopping list. I think there are open questions about how subscribers should be able to enjoy effective appeals for being included on repeat infringers lists. And I think that there are a number of impacts of the Digital Economy Act, for example, on the reputation of ISPs, also on the reputation of Ofcom, frankly, which have not been examined in any of the impact assessments, and which I hope we can have the opportunity to further discuss and debate. It's, in a sense, it's a difficult position given the structure of the framework that the Digital Economy Act puts into place, because if we claim it doesn't work in Phase 1, that's an argument for rushing to technical measures. I don't want to say that a new system of information exchange and warning letters and so forth will necessarily not work, but I think we really do need to come to grips with some of the unintended consequences of this legislation and ask the fundamental question, which is, given what we know about the impact of the legislation on its intended objectives, i.e. reducing illegal copyright infringement, and I certainly think artists and producers and owners of intellectual property should be paid, given what we know about the impact on its intended objectives, and I would say quite little. We know quite little in terms of the current research on that, about that impact. Is it proportionate to have this very expensive and very cumbersome framework in place? And a more fundamental question, this has been dealt with in the debates in France and in the European Parliament as well. Are we introducing appeals mechanisms and private bodies, new roles for private bodies, which are ultimately dealing with fundamental rights and also freedom of expression, and also, I think it's been mentioned, issues relating to cutting off internet connections, closing down Wi-Fi connections, when those the government at the same time is trying to switch off public services delivered by non-digital means.